Thanks, Chair. Clearly, we disagree fundamentally with this legal opinion. I believe the legal opinion is flawed in its entirety. I ascribe that to the short notice that was given to prepare. In circumstances where somebody is currently appearing pro bono for a member of this panel, and there's a financial benefit for the member of the panel in that relationship, to interview that person for a job, there's not only a clear conflict, never mind a perceived conflict, there's a conflict of interest and definitely a perception of bias, and it's ineluctable, and it's inconceivable how that cannot be seen in this legal opinion. Again, a member of this panel is going to interview a candidate who worked for her, who was disciplined by her, who was terminated by her, and then went to the Labour Court and that termination was overturned and she's still in the Office of the Public Protector. I disagree fundamentally with respect with this legal opinion, and I'll need a little bit of time to consider our position.
Thank you, Chairperson. Thank you, Advocate. Are you Advocate?
I am not Advocate. I'm an attorney of the High Court of South Africa.
Okay. You know, this agency was unfortunately created by the very same DA, because indeed, in the first place, apology to you to be just placed in this position unnecessarily, because DA should have raised this query, as Honorable Ngola is saying, when we were conducting the shortlists, and say this is a challenge we are having. And now even EDA, they just rush to Honorable Breytenbach or Honorable Horn. You know, I was still going to declare because I know I'm supposed to declare. And what is worse is that now they raise this here, taking our time to interview candidates. Candidates have been flown in. The state is wasting resources to fly people in. Some of them might have booked earlier flight. Now we are going to delay them. When we change flights, we are losing money. So I think that's also one of the things which they should be accountable for. But then another thing, I'm not the sole decision maker in this matter. The matter is a committee decision. When we identify a candidate, that candidate will be the decision of the committee, not me alone. And again, she's misleading the committee who advocate Breytenbach. The Pona Mkhaladi was never dismissed. The letter was saying, show cause why you shouldn't be dismissed. That is there throughout the papers. Not to say there was a letter which says you are dismissed. So that's very wrong of her to even mislead this particular committee. Who advocate Tibeila is a public defender, a person who do any matter anyway, who saw the cause of the public protector and said, I am also doing the work with the African Union. I can do this matter. I've done several matters which he can present himself if he does that. And indeed, I have no knowledge and relations with Advocate Tibeila. But the fact of the matter is that they just, she rushes to raise this matter instead of waiting for me and hear from me whether I'm going to declare. And I was still waiting for her as well to declare, because there is recorded evidence which shows that herself has been communicating with Ms. Mkhaladi throughout my term as the public protector. So I think it was going to be very interesting as well for her to say, I know this person, I always communicated with her, I'm the one who also gave this information, I raised these parliamentary questions because I was engaging with her. So I think rule 30 is very clear, and I'm not the sole decision maker, and I'm here just for the people of South Africa to make sure that we identify a correct person. Thank you, Chairperson.
The legal division of Parliament, they know exactly how we operate under normal circumstances. we take their expertise and their legal advice very seriously, and we always communicate with them in time. But it was a serious issue that came in the morning, and we needed to get some form of a guidance so that we don't act arbitrarily. We know that there was not enough time to give us a considered view, but we do have a sense now as to whether we agree or we disagree with the view, but we do have a sense. I think we can be able to make a decision, but Mr. Nani?
Before you go, Chair, I think there's one important other aspect that just must be put on the record. A formal finding by this Parliament about the Mkhwebane issue. Ms. Breytenbach will read it into the record.
Okay. Thanks, Chair. So this is an extract from the Section 194 report.
From?
The Section 194 report. Advocate Mkhwebane's rejection of the outcomes of the disciplinary process, the tenor of her letter imposing summary dismissal instead, and the lengths to which Ms. Mokhaladi and Ms. Sekele were compelled to go to vindicate their rights and secure their livelihoods, caused members to conclude that Advocate Mkhwebane's conduct constitutes either victimization, alternatively harassment, alternatively intimidation against both Ms. Mokhaladi and Ms. Seleke. That is an extract from the Section 194 report. I can make that available to the legal advisor if she so desires. And I understand that in my absence, Ms. Mkhwebane said that I should declare about Ms. Mokhaladi. I don't know if she's here. I don't believe that I've ever met Ms. Mokhaladi in my life. But when she arrives, if I do know her, rest assured, I will declare.
Thank you very much. Let's proceed. I think firstly it would be proper to say, Honorable Mkhwebane, having had everything else that has been said, legal opinion, would you still want to proceed to be part of the committee?
Chair, I'm representing the masses of the people. Chair, I'm not here as Mkhwebane Public Protector. I'm here to make sure that I assist the committee. And I still repeat, I'm not the decision maker. I won't impose candidates on you, unless then twisting this thing and saying Advocate Breytenbach and Horn, Mr. Horn, they would want to appoint Ms. Mokhaladi, or because there seems to be the head defense lawyers. So it might be tainted also in that aspect. And I still repeat that she knows her. But Chairperson, be that as it may, I'm legally qualified. I have objectivity. I'll make sure that I assist the committee as best as I can. And I've got no interest in any individual. My interest is only making sure that we get somebody who will protect the public. And that's it. And unfortunately, I won't even recuse myself because I don't see any need. Why must I recuse myself? And I mean, DA should have raised this at the beginning, and we should have given enough time. And even the recent judgments of the Section 194 committee, which you must go and look into, the very same thing one was raising about the recusal and the refusal of their member, Mr. Mailham. It deals clearly with what is expected from a member, and I'm bound by the rules of Parliament when I'm sitting here. Thank you.
Honorable Breytenbach.
Thank you, Chairperson. I want to stress that what you're arguing here is a legal principle, and it's not personal, and shouldn't be perceived as a personal attack. Certainly not intended as well. You're arguing an entrenched legal principle. We disagree fundamentally with going forward with this process under these circumstances. We would urge you, Chair, to postpone this entire event until we have certainty on the legal position. We believe that the process has been fatally compromised. And by continuing it, you're compounding the issue. And by continuing in the face of a legal opinion that is now outstanding, you're just placing enormous pressure on legal services to find a way to legitimize the process. It doesn't allow them the room to objectively apply their mind. And those are our concerns, and I was under the impression that we were going to wait for the legal opinion and then decide on a way forward. If what the committee is now suggesting to do is to go ahead regardless, well, we can't agree with that, Chair, at all. And we again place our objections on record.